Welcome everyone to this webinar that we are organizing this afternoon, and I would immediately like to give the credit to Talia and Antonio, who took the initiative and who brought this very nice group of speakers together to talk about law and technology and the many dimensions of this theme. As you will have seen, we have a very full program with a lovely lineup of speakers, so I will not spend too much time on introductions. Let me just say, my name is Chantal Mak. I'm a professor of private law at the Amsterdam Center for Transformative Private Law. And I've been working a lot with Talia and Antonio, who are the organizers. So let me also immediately introduce the two of them. And then I will introduce the other speakers as we go along. So Antonio is currently a Marie Curie fellow at our group. He's working on a project on fair personalization in consumer law. He did a PhD at Scuola Sant'Anna in Pisa, and he's also a postdoc at Lewis University in Rome. And he's actually still in Italy, but hopefully we'll be able to welcome him to Amsterdam soon, finally. And his co-organizer is Dr. Talia Dielmas. I'm sorry, Talia, I still don't manage to pronounce your name very well. Talia is currently an assistant professor at Bilkent University in Ankara, and she spent the past academic year with us as a visiting fellow at ACT. And we're very happy that the two of you took this initiative, and we're looking forward to a great afternoon of discussions. So let me introduce our first speaker, Professor Roger Brownsworth, who has so kindly accepted to be our keynote speaker, who will give the first presentation this afternoon. Professor Brownsworth is a professor of law at King's College London, and he has written extensively on many issues in the field of law and technology. We are looking forward to your presentation, Professor Brownsworth, and the floor is yours.
Thanks very much, Chantal, and thanks to Antonio and Talia too. It's great to see you all. And you know the saying about London buses, that you wait a long time, nothing shows, then all of a sudden you find there's some more buses than anyone could need. Well, it seems to be the same. Oops, sorry. It seems to be the same with private law and technology, and exactly the kind of topics that you've set up for the webinar today. That this is the first of several such events that I've been invited to, and I have to say, I think I probably shared this with Talia, that my initial reaction in both cases was, I don't really think private law's got much mileage in dealing with these kind of problems. But of course, the thrust of the seminar and the spirit of it is to try to think hard about what private law can contribute. And so that's okay. So, you know, if you imagine a questionnaire coming around, just one question on the questionnaire, and the question starts off by saying, here's the context, we have these emerging technologies, and they're raising concerns about new imbalances of power in our society. Yeah, we think this is problematic. Question, is private law the solution to these problems, or at least part of the solution? And then you're presented with just two options. One is yes, is the answer to that question. The other is no. I don't think anybody would feel very comfortable with ticking either yes or no without some qualification. But if someone says no, that's the only, you have to say yes or you have to say no. And I think my inclination would be to say no. Private law is not going to be the answer, certainly not the answer. And if it's yes or no, well, no, not part of the answer, not part of the solution either. But I would want to qualify that in a heavy way, because I wouldn't feel happy ticking either yes or no in response to that. And so what I will say today are four things, which are kind of qualifying remarks in relation to a question that comes to you in that form, where you have an open box for comments. And these are the kind of comments, the four comments I would want to make. So the first comment is that, of course, we should not underrate. When I'm saying no, it's not the solution, but we should not underrate the capacity of private law to generate answers to at least some questions. To what extent private law can correct new imbalances of power was the particular question, particularly where it's technology related. And it's not a new question, because in Warren and Brandeis's very famous article back in the 1890s, and one of the very early issues of the Harvard Law Review, I'm sure you all know their article on the right to privacy. Anybody who's read anything about privacy in the Anglo-American literature will know Warren and Brandeis's article. It's seminal, really is. So the problem there, you remember, was the technology that there was a problem was photography. And as I understand it, in the earlier part of the 19th century, when photography was in its still very early years, it was practically impossible for photographers to take photographs of their subject without the consent or authorization of their subjects, because subjects had to actually sit or pose, or it had to sit for the photograph to be taken. But then the technology had moved on, and by the time that Warren and Brandeis were writing in the 1890s, it was possible for photographers to take photographs of persons who had not given their consent, who had not authorized the photograph. And for Warren and Brandeis, this was problematic. There was a new, if you like, imbalance of power. I don't think they put it in those words, but there was a new imbalance of power there, and they felt that photographers were abusing a technological privilege that they now had. Well, very early on in the article, they praise, what's the phrase? Bear with me for a minute. Yes, right. The beautiful capacity for growth of, well, they say the common law, but here, that part of the common law, which is private law. And I imagine they would say similar sort of things if we were in a civilian jurisdiction. The beautiful capacity for growth. And of course, the whole of their article is then dedicated to showing just how from the seeds of tort law, where there's no direct physical damage to personal property, but some other kind of harm nevertheless, we can articulate and crystallize an idea of privacy and an interest in privacy and a corresponding right to protect that interest. And of course, the development of the right to privacy in the US case law from Warren and Brandeis onwards went on apace, so that by the middle years of the 20th century, 50 or 60 years later, in a famous article in the California Law Review, Dean Prosser was able to identify at least 4, very clear strands in the way the jurisprudence had then been developed. So privacy was up and running, and moreover, Warren and Brandeis say in their article, not just that common law, private law has this capacity for growth, we don't need to trouble the legislature. They almost use those words. We don't need to trouble the legislature. We can do this without any help from the legislature. We can do it all. Leave it to us. Okay, so now that kind of confidence in the common law or in private law is repeated 100 years later from Warren and Brandeis, not in relation to privacy, but in a very famous intervention by Judge Frank Easterbrook, what I think was probably the first big conference of cyber lawyers in Chicago in the 1990s. Again, like the right to privacy, anybody who's interested in law and technology will probably know this phrase, the law of the horse, which derives from Easterbrook's intervention, the law of the horse. Big headache for cyber lawyers, because what Easterbrook was saying there was, okay, all you people here are very passionate about software and computers and how the law is going to engage with these new technologies. But you come here to this conference talking about the law of cyberspace or cyber law. Well, that's not really very appropriate or helpful. We as lawyers, the way we think is that we recur to the cornerstone principles of, in this case, private law, of contract and torts and property, or in the UK, equity and trusts, restitution. We have these core principles, very basic principles, which are the kind of build or the cornerstone, yes, of these bodies of law. And we have all sorts of novel situations. Some of them involve new technologies, some of them do not. But always what we're trying to do is apply these principles to these new situations. That's what we do. That's what thinking like a lawyer is like. That's what Warren and Brandeis were doing in a very creative kind of way. That's what we should be doing here with computers. And in fact, Easterbrook himself was involved in one of the very early contract cases about giving reasonable notice of terms and conditions on software, in which he, true to his word, had simply applied basic principles of contract law, and he said famously, well, every time something came along that interested us, that was novel for us as lawyers, we were to then set up a new body or area of law, you know, this would be like lawyers who happen to have an interest in horses coming along and suggesting they should teach or research the law of the horse. And he says that would just be ridiculous. So very confidence there that, that again, like Warren and Brandeis, we have the resources within our private law principle to do an awful lot of things when we confront these new questions, problems. And just the third piece of evidence in favor of we shouldn't underrate private law. Another American, in a book published just this year called Runaway Technology by an author called Joshua Fairfield. I don't know Josh Fairfield, but Josh Fairfield's book Runaway Technology goes off in another direction for the most part, I think, but in somewhere in page 50s, and again repeated on the page about the 70s of this book, you find him talking about the way that when questions arose in the American courts about spam and about you know, aggregators who are skimming material off websites, that judges there in a creative way recurred to old ideas of trespass and generated sort of, you know, reverse entry idea of not cyber trespass to give the kind of protection that they felt was warranted in these scenarios. So once again, imbalances of power that are new, but you know, it's a challenge, it's a question for private law, but it rises to the challenge. And this is all a very good positive story about private law, you know. So my first point is, yeah, we shouldn't underrate it. It does have some capacity, okay. But the other side of that point, and the second point, is we shouldn't overrate it either. We should not overrate it. In the stories that I've told you so far, whether it's Warren and Brandeis or the judges in the cyber trespass cases, or indeed Easterbrook himself, we have judges who are prepared to use their imagination and creativity to rework, to refashion these materials. Now, not all judges are so creative. You know, there's a tendency to be quite conservative, especially if you are a lower level judge where your function is to apply the law as conventionally understood. And if you don't do that, you're liable to face an appeal, and the appeal courts are liable to reverse your decision. And you might, you know, your reputation might not be done any favors by if you get turned over too frequently by appeal courts who are critical of the way you're trying to take the law. So, I mean, there are contexts in which I think judges can be more confident in exercising their creative powers. Actually, I mean, this is a side note. In my earlier days, I should say, where there wasn't much turnover or churn, as you might say, within our apex court, which was then the House of Lords, the same judges were sitting in one case after another. They were very conservative. Now, where we have judges retiring at 72 or whatever, and they're only in the Supreme Court for a few years, they want to make their mark. There's far much more energy in our Supreme Court now than there was in the earlier days. So, you know, you get judges turning much more creative, ready to turn things over. So again, I mean, I've talked quite a bit about the American jurisprudence, and, you know, there too, you find the other side of this coin, that some judges have been very slow indeed to respond to problems where there is a new imbalance of power, particularly in biotech. You may know the famous John Moore case, which is a question about whether, well, in this case, a patient at a hospital who has a cancerous spleen removed, whether the patient then has any kind of proprietary interest recognized by the law in the removed tissue, which has now become potentially very commercially valuable to researchers downstream. Well, you know, to get the case up and running, to get the claim up and running, which is going to be, I mean, the lead action is going to be a tort claim for conversion. You need to have a property base for that particular tort. So unless the tissue is recognized as a proprietary thing, you just don't get to first base. And in that case, and which went through several courts where different views were taken, the courts weren't very confident about attributing new property status to things like detached human tissue, or of course you could say personal data, you know, in other contexts. There's a reluctance to do that. And in a book by Dov Fox called Birthrights and Birth Wrongs, the whole book, which is a critique of the American jurisprudence on tort claims arising from new reproductive technologies and new genetics. I mean, it's a critique and a criticism of, which is precisely of the reluctance of American judges to rise to the challenge. You know, they were not prepared to rework these older tort or older private law ideas to get out the kind of remedies which you might think were needed here. So, you know, okay. Now, that's not saying that private law doesn't have the capacity. It's just saying that you have to have the right judges in the right kind of situation to energize it and to take advantage of that capacity. And briefly, I'll just say, when I enrolled at the London School of Economics in 1965 as an undergraduate law student, I wasn't aware of it, but there was a crisis in English contract law at that time. The crisis was that English contract law, which was mainly about commercial contracts, was built on the cornerstones of freedom of contract and sanctity of contract. They were the two keystone principles. Now, in the immediate post-war years, of course, there was great austerity in many countries in Europe, and the UK was. I remember, I mean, there was rationing, for example. As a kid, I was, you know, my mother used to take me along with her ration book to get orange and butter and stuff. You know, there wasn't much of a consumer marketplace. You know, as you would know it these days, unrecognized. But one place where a consumer market was beginning to grow was in the second-hand car market. And it was a particularly shabby marketplace because second-hand cars that were being offered for sale were pretty poor quality cars. Now, the dealers or the finance companies who were facilitating had their standard terms and conditions in play. You know, purchasers who were not at all streetwise, you know, routinely signed up sales agreements in which they accepted all the risks of the motor car not being of, you know, acceptable or satisfactory quality, not being fit for the purpose. They took all the kind of risks which nowadays say, man, you know, these are mandatory terms. Suppliers in the consumer marketplace can't just shift the risk like that. But the principles of freedom of contract and sanctity of contract say differently. So, no, provided this is clearly presented to the other party and they sign, you know, they've accepted the deal's done. And so in case after case coming into the courts, and particularly the Court of Appeal in the 1950s and in the early 1960s, well, as I say, was just the time I was arriving with law, you have appeal court judges very uncomfortable and unhappy about what's going on here, but struggling to find a way to deal with it because one of the great, I mean, the most famous thing they did in the Lord Denning's court was to come up with the idea of fundamental terms or fundamental breach. No one really knew what the difference was. But whether it was a fundamental breach or a fundamental term, the Court of Appeal had said you could not exclude liability in relation to those terms to which the breach or the term related. And the core terms of contract, as we might put it these days, were fundamental terms. So, you know, so for this Court of Appeal, they were trying to say there's a kind of inner core of every transaction where the parties can't exclude liability. And that was a massive, I mean, people in Florence might have said correction, but a massive exception from freedom of contract and sanctity of contract. And when that, now in my first undergraduate year, our House of Lords managed to work an appeal where they got this point presented to them. It was an out-and-out commercial case, but they managed to use that as a platform to pronounce on this point. And their pronounce was, yeah, these principles of freedom of contract and sanctity of contract, they apply every bit as much to what we would now call consumer contracts as they do to commercial contracts. They are the fundamental principles. But what they mean is that parties can, you know, write pretty much any terms and conditions they like, provided that they really do agree to them. So that threw the onus back onto the courts down below to try and find ways of saying that the consumers have not really agreed to these terms, even though they were clearly written in the standard forms in question. And for some years, you know, you have a game being played on that front, but it's clearly unsatisfactory because on the one hand, this wasn't really doing what was required in relation to consumer transactions. It wasn't giving consumers rights. At the same time, it was creating mayhem where these precedents were now being cited in commercial cases, where questions were now being raised about charterers, you know, or contractors in construction, all sorts of heavily, heavily professionally advised parties pleading that these rules, which are now being made for purchase of second-hand cars, applied equally to them. And I mean, this was the backwash from this was really terribly serious. So this could not be sorted out by the courts. And in the end, in the UK, as I think in a number of European countries, we have legislation introduced. In England, it's the Unfair Contract Terms Act in 1977, but we have legislation introduced to try to clean this up. Okay, but the cleaning up is not an exercise in private law. And here's a key point. It's not an exercise in private law, not because the courts didn't do all the work with it. They had to rely on the legislature. No, that's not, I mean, that's relevant, but that's not the key point. The key point is that the thinking behind the Unfair Contract Terms Act is not the principles-based thinking that's characteristic of private law thinking. Okay, it's what I would call regulatory. Because what's going on in the Unfair Contract Terms Act, as has happened in the European Union time after time, as new deals, in inverted commas, have been crafted for consumers or for data subjects, I mean, wherever there's a new deal on offer, the thinking from the Commission is regulatory. It's policy focused. There is a policy that is driving this. Now, of course, in the early days of the European Union, the key policy here was about, well, twofold really, but I mean, the creation of the harmonized marketplace across Europe, and consumers having the kind of confidence that they needed to be able to buy across border and move away from their local markets. But a European-wide market was no market that is driving policy. So it's policy focused, it's policy driven, and what they're trying to do typically when new technologies are involved is, on the one hand, not interfere in a way that's going to make it too onerous for particularly smaller businesses that are trying to innovate or develop these technologies, which could be extremely beneficial, like platforms or cryptocurrencies, whatever it might be, where there is potentially some advantage for the community. But at the same time, you can't give it a free pass. So the regulatory package or accommodation has to make sure that those risks which are really unacceptable, particularly for consumers, that they are properly taken care of. So like with artificial intelligence or machine learning, again, I mean, on the one hand, you don't want to kill the golden goose here. You don't want to make the regulatory conditions so onerous that no one's interested in developing artificial intelligence or machine learning. We want to get whatever benefits we really can from it. But on the other hand, all this talk about human-centric applications, we have to make sure that those risky applications, and of course in the new, the draft regulation on AI, you have all this stuff about high-risk applications. You have to understand the risk profile and make sure that appropriate, management of the risk is in place through the law. And this may often involve, the management of risk may mean there are big adjustments from what private law would normally recognize. So that instead of fault-based liability, you're going to have strict liability or some no-fault compensation scheme. Or there might be immunities, of course, on the other hand, conversely, as there were effectively for intermediaries in the early years of e-commerce. So this is taking me, I've kind of moved, I'm sorry, Chantal, I'm just going to finish this quite quickly. I'm conscious that we haven't got a lot of time, but and I'm talking much more quickly than I normally would want to. But I've already moved on to the third point, which is that one of the limits of private law is that it's not designed to make regulatory judgments or regulatory intervention. Private law kind of assumes there is a regulatory accommodation in place, and where there's some wrong, which produces some imbalance that needs to be corrected relative to the existing regulatory arrangement, then private law will intervene to correct it. So it's kind of, I know in contracts we don't think it's just about restoration of the status quo, but typically it's about it's about corrective justice. It's about trying to correct and return things to where they were. But it's not about trying to put in place a completely new distribution of power or distribution of benefits. So it's not about that. This is for regulators to do this kind of thing with the kind of mandates we expect people who do this have in democratic societies. You know, judges who go off on rewriting the rules of the ground rules in a major way will be thought to be out on a limb and not really having the mandate or the expertise or the resources to do any of this. So we expect others to do it. But the important point is not so much that it's other agencies doing this, as that the exercise of regulation is a completely different kind. It's policy focused rather than principles based. And as I say, with new technologies, it's about trying to strike a different balance between the stakeholders, an acceptable accommodation. But it's also about making sure, as the European Union always says, that these new technologies are not applied in ways that compromise the fundamental values to which Europeans have committed themselves. So, you know, human rights, or whatever it might be. So if you have, I mean, for example, you look at a case like Google Spain, where there is a new imbalance of power between, well, I'm not sure who you'd say the imbalance of power is between, but I mean, you could say it's between the prior to the search engine, or you might just say it's between those who use search engines and those out whom searches are being made. But you know, there's a new imbalance of power there, and in Google Spain, the court is prepared to intervene to adjust this. Now, that intervention is, well, I don't think it's an exercise in private law. It's either a tweaking of the regulatory accommodation that we have in the had in the data protection directive, but would now have in the GDPR. It's either a tweaking of that, or it's an appeal to Articles 7 and 8 of the European Charter, whether you think it's privacy or data protection. These are the fundamental values. I mean, there's some confusion, I think, in court judgment as to what is it, because they throw both these things into the mix. It's both, you know, the Charter provisions and the legislative provisions, which I say is, for me, is a regulatory package. But either way, it's not private law that's doing the corrective work there. We've gone beyond the limits of private law. Now, the fourth and final point is that, so to recap, private law does have some capacity for dealing with this, but we shouldn't overrate it because its limits are set by both regulatory exercises and public law and the fundamental values constraints as well. But the fourth and final point is that if we're talking about private law as part of a national legal regime, however you define private law, so long as it's limited to the national, that can't then adjust imbalances of power that go beyond nation states, are more kind of cosmopolitan or international in their origins. A lot of what I've written, I've had several bites of this cherry, too many probably, but I keep saying that beyond, if you like, beyond private law, beyond public law, beyond the nation state, there is a set of preconditions for any community, like a nation state, to express its own, aspirations and its fundamental values, and arrive at its own accommodation of competing and conflicting interests. But there are preconditions for we humans to inhabit this planet Earth in the first place, which environmental lawyers are constantly reminding us about. It's not just that these are important. If these conditions fail or are compromised on the environmental side, then that's catastrophic. Well, of course, with climate change and with pandemics so much in the news, then of course we don't have to think very hard about the kind of problems we're talking about. These are going, but there are also beyond the existence conditions or alongside the existence conditions for it. There is a context or a set of preconditions again, which create the possibility of our having the capacity with our own purposes to do our own thing in our own way, form our own relationships, form our own projects, and also not just to take account of our own interests, but to have the capacity to take account of the interests of others as members of community. So the capacity for self-development, the capacity for moral development, that needs certain sorts of conditions. And a lot of the imbalances that we now see around, all the debates about surveillance capitalism, Tishana Zuboff and again, Julie Cohen's work. These aren't just systemic problems. They are, for me, these are problems that go reach right back to the preconditions for our agency, or some people say our liability as autonomous person. If the technology is dictating what we think is in our self-interest in ways that there's no gap between ourselves and these technologies, then we have serious problems. Yeah, I mean, so I could say a lot more about that, but in the time that kicking this off, I can't put that here. But so I hope that's given you a bit of a backcloth, anyway, a bigger picture. And I'd be very interested to hear what your particular contributions are in relation to the things you're going to be talking about. I apologize again if I've gone on longer than I have gone on longer, but I'm sorry. I tried to get through that as quickly as I could.
Thank you so much, Professor Brownsworth. Roger, if I may.
Yeah, of course, Chantal.
For taking us through this development of law and technology, and also the development in the courts and in legislation. I'm sure this gives many points for the start of the discussion. I must also admit that Antonio, Talia, and I have been quite optimistic and ambitious in putting so many great speakers into one program. So my suggestion would be that we first listen to two of the other presentations and then group the questions in one round of discussion. And therefore I would like to kindly ask the audience, if you have a question for Roger Brownsworth, could you please type the word question in the chat? Then I will make a note and I will give you the floor as one of the first discussants when we go to the Q&A. But thank you again, Roger. This was really brilliant, a brilliant start of the discussion. And I suggest we now go to our next small session in which we grouped the presentations by Christine and Antonio. So let me introduce Christine, who is here with us today, also from the UK. Christine Riva is a reader in law at Brunel University in London and a great expert on law and technology and consumer law. And I'm very happy that you're here, Christine, that you're able to join us also from the UK, and very much looking forward to your presentation. The floor is yours.
Thank you, Chantal, and thanks very much to the team in Amsterdam for inviting me. I've been looking at what the Centre has been doing for years, and in this prior incarnation and in the current one, so I'm very excited to be here. It's quite a nice setup for what I had to say to hear Professor Brownsworth before, because I think I do share perhaps the feeling that he has expressed that private law might indeed have a fairly limited role in helping consumers, since it's what I'm going to be focusing on, at least in the first instance. So what I will be talking about today is how to achieve fairness for consumers. And this is partly sharing some of the research that I've been conducting on what we've branded with my co-authors, Paolo Siciliani and Harriet Gamper, Fairness by Design. We kind of jumped on the trend when it was still very new. And obviously for those of you who are aware of data protection, you will have heard the expression privacy by design, which was brought in by the GDPR. And we've seen a fairly hefty development of those by design obligations, or this idea at least of trying to push businesses into taking more responsibility. At least that's my interpretation of it. And we didn't set out in the work that we conducted with my co-author to arrive at a by design obligation for traders, but that was more or less the result of our inquiries. The book, which is Consumer Theories of Harm, that's its name, it's a little bit of a concept that might confuse some people, but it's actually a book that tries to look towards economics for some solutions to consumer problems, or at least to give regulators and enforcers a blueprint to know when to act and justify intervention. So I suppose because of that, it's actually not, the premise of the book is really not putting a lot of trust in private law in being able to sort out the problems. So I'm going slightly against the grain, I guess, today with my comments. The reasons for the books and the solution we've been trying to look at is, if you look at consumer law, and that's all I'm going to limit my comments to, you will find that the consumer lawyers in the room, I'm sure, will agree with me, there are a number of facts we cannot escape. Fact number one, consumer law promises a lot of protection to consumers and actually doesn't deliver that much. It's quite hard to get redress. There's always a sense of we've been had, the goods are not very good, we thought they were going to be better, they were quite expensive. So there's a lot of expectations that are not always met, and it's always very hard to repair harm, even after the damage is done, but even harder to prevent the harm to consumers. Fact number two, competition law, which is often branded as this tool that will help all consumers and protect them adequately, and therefore we can let markets do their thing. Consumers will buy only from good traders. We can intuitively sense it doesn't work either, at least not in isolation. It does fail on its own to deliver fair markets, although it's been not without trying for many years and trying very hard as far as regulators are concerned. So we can't rely on competition law alone to solve consumer problems. Consumer law itself and the body of law that was developed at European level elected to protect consumers and has done some fantastic work. I don't want that to be taken away from the legislator and all the efforts, but it has done this job primarily by relying on information of consumers as a main tool for the regulation of markets. So it's always gravitated towards this illusory and I think completely outdated concept of the average consumer, who, given all the information, will of course compute all of that and, hey presto, always make the right choice. And therefore we don't need competition law so much, because if consumers are always able to make the right choices, then competition will sort itself out, the markets will self-regulate, because consumers are able to vote with their feet. They can actually drive the bad businesses out of the marketplace. Again, completely not happening. Fact number four, that is quite important in setting up what I want to say, is that digital markets have really accentuated, exacerbated the difficulties that we were encountering in consumer markets. So technology so far also has failed in many ways in bringing tangible solutions for consumers. So I remember quite a while back when we had price comparison sites, everyone was like, okay, well, this is going to sort it, no problem. Now consumers can compute the information, they've got the tech to help them, and actually what's happened is, because of price comparison sites, then the markets became more opaque so that the price comparison site couldn't do the job. So in fact, it's accelerated again consumer detriment by changing the rules of the game. So digital markets are making the life of consumers very difficult, and they have, I think, pushed more businesses towards bad behaviors. So I'll give you the example, which I think is the simple one for everyone to understand, because we all live it on a daily basis. Traders now, even the good ones, have got to collect your data, because they have to make the information you see relevant, because otherwise the next guy that is not so good will have done it and sold the goods to you. So even if you want to be a good person and you don't want by default to collect the information, and very few of the websites you will now visit, you will notice, actually have crossed out and said you do not consent as a default. They're very rare, actually, if you come across them. Continue to use them. Most of the websites we go on to have by default said, okay, you're going to consent unless you say no. And if you try and do the exercise, you're spending half your life doing it. I do it systematically. And I thought at first it, but lately you've seen appearing the legitimate interest thing. So now it's not just consenting to the use of your data, you also have to deselect what they could do in the future if they had a legitimate interest. Of course, as a consumer, you have absolutely no way of checking whether you said, I don't want you to use my data is actually happening. So they are pretty much in the driving seat. And I think that's a huge problem for consumers in whatever product or services you want to engage with. So the result of all of this is that we now are witnessing consumers more or less disengaging from markets. We become apathetic. We just say, oh, you know what? Oh, gosh, I've got better things to do with my life. Okay, consent. And then we are told, but you're consenting. You like your data being harvested. Well, I don't, but I don't have an alternative. So I have to consent. And we have seen also in that race that there's been more and more changing with dark patterns that are now being discussed a lot, where we are making it an obstacle course. So where does that leave us, and how do we bring that back to private law? Well, I think consumer law was built to be this tool that would move us away from freedom of contract and would offer some protection. And in fact, from my point of view, and I'm not a contract law lawyer, so I need to disclose that, it seems that we haven't changed anything. We are still relying on consumer markets that are requiring consumers to beware and are not requiring businesses to behave. And that's where the book comes in and the work we've done kicked in. We turned to economics to try and understand why that was and what were the economic incentives for all those businesses to behave that way. And could we find a way to incentivize them to actually behave well and be good guys as opposed to bad guys? And again, I don't want to use that because there are plenty of businesses that are great and often find themselves in that downward spiral, which is not of their making. But to simplify the matters for the little time I have, let's just continue with this idea. So where we find the problem is in private law, you always have this debate between, oh, if you regulate too much, you're being paternalistic and you're doing those things, and that's not quite right. And economists tell us actually the Homo economicus is well capable of making good decisions. We obviously know that's no longer true. Neoliberal economics has been largely discredited. Behavioral economics offers some solution, but in the book, we moved away from that. I know we've upset a lot of behavioral economists in the process. And it's not because we don't think behavioral economics is not good, but we think the use that it has is limited, primarily in making disclosures better, which is obviously welcome. But from my point of view, I want to stop this situation where it's always for the consumer to understand the information and make the choice, the right choice, because we're effectively vilifying consumers who are not able to avoid a bad credit deal, who are not able to escape their data being harvested. Well, you consented. And I don't think that's right. I think fairness surely requires a different deal for consumers. So instead, in consumer theories of harm, we are exploring all of this detriment that is caused by consumers through the prism of the work of Herbert Simon, who's an economist who actually is the seminal work that is being used also by behavioral economists. His idea is about bounded rationality. So it's about consumers being rational, but we have limitations. Our brain can only manage a certain amount of information. And with this, we started to reimagine how consumer law could function. And we find that we already have the tools. I think I like when Professor Brownsworth actually talked about the fact that there's no need to trouble the legislature. We already have the tools. We don't need to trouble them. We just need a few judges that are going to have the imagination to reinterpret the rules of how we need to protect consumers. And indeed, for us in the book, the main idea is that consumers, the average consumer who are supposed to be rational, we think it's rational to disengage. We think it's completely spot on for consumers to go, you know what, I'm not going to shop around, because why would I change my electricity tariff? I'm going to spend the afternoon doing it. I might as well earn some money. And at the end of the day, I'm going to have to do it every year. And I'm not sure I'm getting the best deal. There's also some really interesting research in the UK that shows that consumers that do shop around and are those good citizens actually are more disappointed with their choices than the ones who didn't. So actually, it's in terms of well-being, it's not very good to be the average consumer and do the work. So you might as well go, hey, whatever, let's see what happens. But we think we can actually reinterpret it in that way. And the Unfair Commercial Practice Directive offers the perfect tool to do this and do this now and protect consumers more effectively. We can do that indeed by looking at the average consumer and interpreting that person to be someone who has bounded rationality. The directive allows it. The Court of Justice of the European Union has never prevented a national court from having a different interpretation, and therefore it can be done. We are welcoming the judges who will want to depart from that. So far, we haven't found any. We also can look at the general clause in the Unfair Commercial Practice Directive and have an interpretation of professional diligence that will lead to businesses really behaving. And what we mean by that is that we believe that to achieve a higher standard of consumer protection, the normative standard of professional diligence should discourage opportunism and promote trustworthiness. And we think that this standard should in fact be interpreted to prescribe assistance to consumers. And that's what it would mean to be diligent professionally. And we see in this way the ability for judges to sanction more heavily and more systematically businesses that are not doing what they're supposed to and are not being fair towards consumer. We also see it as a way for enforcers to be able to engage the UCPD more systematically. With this, and looking at the economics of enforcement and how it should change the shape of markets, we believe that a more systematic use of the UCPD and consumer law more generally would prevent markets going down in these downward spirals and forcing all market players to become the bad traders. And with this, in time, fairness by design should become the default and improve drastically consumer markets and the plight of consumers. And that's the content of my thoughts.
Thank you so much, Christine, for this crystal clear elaboration of your ideas, which go really to the foundations of both consumer law and contract law, but also have very practical insights to offer for the law. So thanks so much. We will discuss in a few moments. So again, to the audience, if you would like to ask questions to the speakers, write the word question in the chat. And then we're going first to listen to Antonio before we go to the discussion. Antonio, the floor is yours.
Okay, thank you so much, Chantal, and thank you to all the speakers actually for taking part to this event. Both the presentations have been super interesting actually and very insightful. I'm just putting on my timer in order to be at least time compliant and to try to save some time. And I'm actually going to share some slides about the presentation I wanted to make to you. Now, I'm actually very happy that my presentation comes after Professor Rifa's one, because one of the aspects, I mean, many aspects that she mentioned are actually also recurrent in my presentation, even though I want to focus on one of the critical aspects that she has been debated, which is the role of disclosure as a means for consumer and for individual protection more in general in the digital age, as as you will see in my research, which is still in progress. So of course, some data still needs to be further elaborated. So since I try to defend that a different way of intending disclosure might actually be more fairness enhancing in B2C relations. Now, as Chantal mentioned at the very beginning of our workshop, this is part of a larger project, which is the fair personalization project I'm conducting, and which aims at analyzing how personalized interactions based on profiling actually influences consumer behavior. But within this wider framework, the research I'm presenting and I'm conducting nowadays is actually based on how it tries to investigate how consumer and individual decision-making more in general is not only partially irrational, so at least in part against what neoclassical economics defended, but also inherently relational, and therefore being this aspect in part neglected by traditional disclosure regulation, the idea is actually to defend a system of contextualized disclosure as a way to promote both consumer awareness in decision-making and trust in artificial intelligence system. Now, going very fast on this aspect because we discussed them in Professor Rifa's presentation. Of course, we know that consumer law is strictly related to the modes of market interaction, and therefore, of course, is related to the analysis of the dynamics of the decision-making, which was already a traditional characteristic of the analysis of individual behavior, but of course has become more prominent in the digital society. So whereas on the one hand we had the neoclassical approach at the very beginning of individuals as homini economici, so that was at the very basis for the development of the many disclosure duties. We then had the behavioral and economics wave that observed that interaction, B2C interaction actually operated in contrast with the rigidity of the conventional economic theory of individual behavior. And this goes both for offline and in particular for online interaction. And the development of behavioral analysis of individual decision-making actually led, on the one hand, to a significant criticism of disclosure duties and information duties as means to generate awareness, as long as actually consumers are, on the one hand, not reading the disclosure rules, and also are subject to information overload and so far and so on, and also critics to the so-called one-fits-all approach to disclosure. So the idea that you can actually provide disclosure to every individual in the same way. And this goes together with the idea of the need of further granularizing disclosure as well as law more in general. Now, this has led to some developments to accommodate behavioral funding, and we have seen in recent years how the principle of transparency has been, up to a certain extent, reinterpreted towards more attention to the accessibility of information and its understandability, as well to regards to the formal aspects of language. But more in general, we observed that disclosure has been moved increasingly towards a substantive approach that was meant to promote fairness, actually, in business-to-consumer interaction. Still, some actions that were present in the neoclassical models, and here I try to defend that there is some sort of problem in how we intended the disclosure models are still present and untouched. And in particular, what I refer is the assumption that consumers are subject to a social individualism as a matrix for developing their decisions. So there is this underlying idea that desires and preferences in information duties are still deemed to be exogenous in consumers, which means that when there is a business-to-consumer interaction, the information that is provided to consumer is not contextualized, so that that consumers' desires and preferences are not affected on the one hand by the fact that consumers observe each other and observe their peers before actually taking a decision, and in order to contextualize the information they receive and interact with other individuals. So, and the absence of this contextualization of information seems to be particularly problematic when we think about power imbalances in the digital technologies realm. So, for example, and this goes, for example, in very recent normative terms. So when we think, for example, about the new directive on the modernization directive, we see that, for example, we have a new disclosure obligation in the case of price personalization, which nevertheless is still an accurate textual model. So consumers need to be informed that their price is being personalized, and which means that this information is not actually contextualized in terms of effect that this technology, for example, this technique, has on the consumer, but also on other consumers, so actually on her peers. Now, of course, in the case of price, which is, this is up to a certain extent understandable because we are talking about a single variable. So actually prices can be lower or higher. So communicating prices personalization seems up to a certain extent to allow consumers to understand that other people might have higher or lower prices. But still, as long as communication is not only about a single variable, but for example, is about the characteristics of products or other aspects that can be personalized in the interaction, these might be even more complicated. And so, and as I said, as long, especially in the personalization, which is my main field of research, this acontextualized approach to disclosure duties seems to further exacerbate the power disparity between professionals and consumers. And this goes actually to how the analysis of consumer data is conducted by professionals. Because if we observe actually the real strength behind the enterprise's capacity to elaborate consumers' data for profiling goals or for personalizing commercial interaction actually is found in the relational analysis of those data, which is based on network embeddings. So actually the single data points related to an individual consumers are put in a multidimensional context, and proximity evaluations regarding those individuals are made in order to evaluate actually how they relate to each other. And if this is actually the reason for the enterprise's power when recurring to data to shape commercial activity, it actually makes less sense that we believe that consumers can be empowered by a communication related to her single data points, so information regarding her individual situation. And this is actually not new to sociological studies. So if we take, for example, the studies by Albert Bandura, who is a Canadian psychologist who formulated in the late 90s his social cognitive learning theory, Bandura observed pretty early that in decision-making processes, individuals are affected not only by, of course, their individual information and their cognitive information, but also by the environment, and most importantly, by the comparison that they make about their choices with a certain amount of information and the choices that their peers took with the same amount of information. And this was a third theory to actually try to introduce a relational element in the decision making. And what I have been trying to do in my recent research is trying to replicate this sort of system by developing a system of contextual disclosure. And what I've been trying to create a design to do that. And in particular, I took into attention the case of personalized practices. And by analyzing studies on legal design, I tried to investigate how the traditional individually segmented disclosure could be improved by a contextual disclosure. And the beta testing I have been conducting has been on the broadcasting market. So in particular by investigating the Netflix personalization system for actually suggestion for movies. Now, going very fast because I'm already running out of time. Netflix actually uses two different forms of algorithms when suggesting movies. And one is traditional personalized video rankers, which is based on the user's profile. and in her characteristics to suggest movies that might be of interest. And on the other hand, it uses a second algorithm, which is called video-video similarity, that is based on the individual's movie's history. So actually, movies are suggested based on what the user has already watched in the past. But even within the video-video algorithm, actually the order of the movies that are suggested are based on the personalized algorithm outcome. So what I wanted to investigate actually was if I could improve consumers and individuals' awareness regarding the functioning of the personalization system and awareness in decision-making by introducing a relational disclosure model. And in order to do that, what we are testing is actually to implement a dual information system. So we have, when the disclosure is made to consumers regarding a personalization system, on the first step, we have the traditional individual information. So the fact that a personalization system is used to suggest movies. And then we have a relational information model. So individuals are able to observe the algorithm's recommendation for people with their characteristics, so the suggested recommendation which is what is happening now, plus the average with the average compatibility rate of those information. But at the same time, and here comes the relational element, the interface of the website shows them also those recommendations that has been made for people with a different characteristics. So for example, with people with very different tastes, so showing, for example, movies for people with very different tastes. And these dual disclosure actually allows individuals to put in context the information they are received and to evaluate better the consequences of, for example, of the personalization, so on the implementation of the artificial intelligence in their data, the data processing. So of course we are still conducting this study, but the first results are quite comforting up to a certain extent. Of course, there are some control variables that we need to take into account. So for example, the familiarity with the profiling service or with the specific service considered, or for example, with regards to Netflix, the fact that we are not in presence of a transactional decisions, because actually people do subscribe to Netflix and then can just choose the movie without a monetary payment. But of course, this will be replicated also with software such as Amazon Prime that actually offer movies for purchasing. But the first result that we are getting is that actually this sort of reshaping of disclosure has actually a fruitful outcome in terms of both consumption rates. So consumers are more willing to accept what the AI is suggesting when this sort of contextual disclosure is made, but also in terms of awareness regarding how an AI-empowered service works and more trust in the artificial intelligence system. So I agree that disclosure duties are not the only solution or the best solution that we have, but there's still a significant margin for improvement, and that's what we are actually trying to achieve. Thank you so much. I hope I didn't take too much time out of your.
Thank you so much, Antonio. This was very clear and very concise. Compliments. It was really nice to hear more about the development of this relational concept of disclosure. And I'm sure that people will have questions to you. So we now have some 10 to 15 minutes for questions from the audience to Roger, Christine, and Antonio. And I already have a few people on my list. So I'm going to collect the questions by Talia and Marco first. Talia, please.
Thank you, Chantal. First of all, I really want to thank Professor Brownsworth, Roger, if I may, and Professor Riefa, Christine, if I may, and Antonio. I learned so much. My question was initially for Roger, but it also involves Christine's talk as well. So that's why I think it will be convenient. So I personally think a lot on the relationship between life and information. And I think Roger's example on this tissue removal of the cancerous spleen and its relation to privacy made very much sense to me. And that made me think of technology affecting us in determining what is rest, what is a thing, what is a person. And this actually requires a certain degree of flexibility which we use private law methods while we identify this status. Therefore, actually, my question is, would this flexibility or the flexible concepts in private law, such as fairness, good faith, equity, whatever we call, up to a certain degree, would they help to increase the answerability of private law, even if we are very critical towards it, to the problems caused by digital technology or the technology of the day? So thank you so much once again for all the speakers.
Thank you, Talia. I'm going to collect some more questions now. Marco is the next on my list, please.
Well, thank you, Chantal, and thank you for those brilliant presentations. I've enjoyed them very much, and I must say that's not always the case when you're watching presentations online. So, Roger, Christina, and Antonio, thank you very much for that. I have a question to all three of you in a way, and that pertains to what I think all three of you actually criticized in a way, is the way that the European Union approaches consumer protection by way of introducing information obligations. They don't work, everybody knows that, but they keep on being introduced again and again and again. And we've now seen that again also, for instance, in the Modernization Directive, nothing changes in that perspective. So my question to you would be, should we not change the paradigm there and move away from information obligations and move towards substantive protection?
Thank you, Marco. A brilliant question. I'm looking forward to hearing from the speakers, but I would like to first collect the questions by Antonio and Klaas, and then we give the whole panel the chance to react. I see, Antonio, you have a question for Christine. Please go ahead.
Sure. Okay. Riva, of course, I mean, I read your book. I'm pretty aware of that. But one aspect kind of came to me when I was thinking about your speech today. So you made reference to professional diligence as a main tool that is actually present in the UCPD as a tool actually to promote some sort of cooperative behavior by professionals and enterprises in, I would say, assisting the consumers. Maybe that's not exactly what might happen, but at least to have a proactive behavior to that. And I agree on that view. On the other hand, but I still think that this can be achieved, and that's where I am maybe less skeptical about private law. This might be achieved with the same amount of effectiveness by referring to general clauses of private law, because what I see there might not only be professional diligence, but actually an exercise of objective good faith in their behavior. So, I mean, of course, I'm biased regarding that because I wrote my PhD on good faith and abuse of right in promoting fairness in consumer protection. So I come from a specific corner of that, but especially in light of the constitutionalization of private law and the vehicle theory as well, I do think there's margin of appreciation for good faith and abuse of right in a wider way to promote this sort of proactive assistance towards individual. So I want to actually your take on that. So why you prefer professional diligence? Why you think that might not be the case? Thank you.
Thanks, Antonio. Here I see a clear connection with Talia. I saw Talia nodding as well, who is also a great expert on the general clause of good faith. I would like to give Klaas Eller the opportunity to ask his question, and then we'll give the floor back to the panel. Klaas, please go ahead.
Thanks, Chantal, and thanks to all the speakers. My question goes to Professor Brownsworth also. And so I was wondering, your reluctance or say your skepticism towards private law, to not overstate private law, seems to come ultimately from a dichotomy view of private law as being opposed to regulation. And specifically in the debates that you referred to, I wonder if this can still really be upheld. Most specifically, you were referring to the Easterbrook-Lessig debate, law of the horse. And I mean, Lessig's argument in saying why cyberspace would not be a law of the horse was precisely to say that we need to think not from a specific field of law, but from the new social or technological phenomenon, which was cyberspace at the time, and to basically collect all legal fields that somehow have to do with the internet, that somehow give shape to the internet. And in this view of Lessig, and I believe, convincing view towards Easterbrook's critique, he basically eradicated any form of differentiation between private law and regulation already. And the second line of skepticism, perhaps towards what I saw sort of shining through in your argument, would come from then the development of European private law, where really the regulatory dimension has been just growing so much, as we all know here, over the past 20 years. So isn't also European law a good example for not upholding this differentiation all too tightly? Thank you.
Thank you so much, Klaas. And another quite fundamental question, I would say. So I'm now going to give the panelists the floor in order of their appearances. And I would like to ask Roger if you would like to be the first one to reply to the questions. Oh, I believe you're still muted. Wait.
Apologies. Yeah, so thanks, Chantal. Thanks for those questions too. Perhaps I can start with Klaas's question first, although that was the last one. Let me try and keep this concise. Yeah, I do want to draw a distinction between private law and regulation, but private law, like regulation, operates normally, as we understand these things, with rules, principles, standards, with normative material. And so, although I can draw a distinction within the body of rules, principles, and standards as the tools for governance, between private law tools and regulatory tools, there is, as you rightly say, probably for the future, a much more important distinction to be drawn between those normative materials which we rely on historically in law and regulation and in ethics and codes, and technologies or technical measures, on the other hand, which I think for me is the point Lawrence Lessig is always making, that we should not underrate the as he put it, the regulatory power of these new tools in information technology, but also in biotech, now in AI, all over the place. Tools which are being deployed for regulatory purposes. In law tech, reg tech, any tech you like to name. For me, the big questions of the present century are not to do with whether it's private law or regulation that has the answer. It's shifted the central gravity of the debate. So that the choice now is between normative standards of that kind, whether they come in a private law or regulatory format, and governance by technologies or technical measures, which do the work for us. Now, when Christine started her talk, I thought when she was talking about privacy by design or fairness by design, she was going to be talking about deploying technical measures or technologies to try to guarantee that consumers got a fair deal. So, for example, if money were going to be paid to a consumer, like for a delayed flight or something, blockchain would have been deployed, a smart contract, in a way that would guarantee that once the delay was triggered on the system, the payment would then be made, irreversibly into the account of the passenger, of the consumer, something like that. But in fact, what Christine was talking about was kind of new incentives, I think, within a regulatory framework that would channel businesses towards much better business practices, which in the end would benefit both them and consumers. But I think, Klaas, you're right. I mean, we could talk all day about this, but as I say, for me, you've asked a question which sort of presses a button for me, which is about the debate of the 21st century. And when in Europe we have these repeated references to ideas like trust, which are ideas, concepts that have made sense in an analog context, quite different context of governance, and we're now trying to translate these across into machines that are doing the regulatory work. And when trust, I don't know Alistair McIntyre's book from the 1980s, After Virtue, but that's a book where McIntyre says that, for Greeks, in sort of classical Greek civilization, in that context, virtue was a concept that made perfect sense. But once you change that context, virtue becomes something that doesn't mean the same thing. And I mean, almost any concept you like to name, fairness, justice, good faith, trust, responsibility, explanation, causation, anything you like to name, that we've developed, privacy, that we've developed in our sort of high-tech worlds, can we now translate those concepts across to these new forms of governance in a way that means they're meaningful? I don't think it's a matter that new tech does governance better than non-tech sort of old-fashioned rules and standards. It's just a radically different thing. It's a paradigm change. So I very much like the question. I apologize for rambling and lengthy answer to that. We're trying to be concise, but I think you've put your finger on such a fundamental thing. Now, if I can go back then, sorry, to Talia, whose first question, I also very much like, I have a good friend in Singapore, well, she's now in Hong Kong, called Eliza Nick. I don't know whether Eliza, who's Polish, but who's most of her life has worked in Australia and out in Asia. But Eliza's always rebuking me for not giving credit for the flexibility of private law. And just the kind of concepts that you mentioned, like good faith and whatnot, which, in England, I suppose maybe the English view is to some extent pathological, because, we had these concepts live up and running in the body of equity. But the fusion of equity with the common law in the late 19th century was actually the suppression of equity. And you find that what happens in the 20th century is that particularly, judges that are commercially minded don't like these fake concepts, too flexible. Business people need to know where they stand, all that stuff. They start downgrading they don't want to have unconscionability in contract law, really, faith, and of course we've had a huge case, I should say, about the importance of relational contracts context, where the technology that was supplied to sub post offices to do their accounting was flawed. And the post office put all the blame on these poor little individuals, hundreds of them, who were then penalized. Some of them were convicted of criminal offenses, sent to prison for defrauding. A huge scandal, absolutely scandalous. So yeah, no, I think the flexibility of these concepts in private law makes it easier for judges to come up with, they don't have to be too creative to do the right thing. And the other point I should make there is that very often the first questions about these emerging technologies are being asked in litigation, in courts. Someone gets harmed or perceives that there's a harm here, and we haven't got our act together in the regulatory arena or the legislature just yet. We know it's coming, but we haven't really got our act together. And the first questions are being asked in the courts, and the courts are being asked to answer those questions by reference, of course, to their traditional cornerstone principle. So private law often is thrown into this in the first instance before we get things together in a more sort of organized way, and take account of the kind of things that alerting us to in a more regulatory package. I know Marco's got a question there that Chantal, may I just say a very brief word on Marco's question?
Yes, please. Go ahead.
Okay. Well, Marco, I wasn't meaning so much to criticize the Commission for their informational strategy, but I was just trying to hold up the Commission as a kind of a textbook example for me of a body that thinks in a regulatory way, as opposed to in the Foundations of Private Law project, what I heard so much of the time was people from the member states saying that, these grand Brussels consumer law projects just don't take sufficient account of the particularities of the member states' regimes of private law. That the regulation is a kind of a bulldozer or knife that just slices into member states' private law regimes without due attention. But I wasn't being critical. I was just saying there's a different way of doing it. But then in the Commission now, the emphasis, like in the GDPR, on technical measures or by design solutions seems to me to be trying to move it into what I call a Law 3.0 mentality, where instead of looking to the rules and standards to do all the regulatory work, as in criminal justice now, we look for the technologies to play a major supporting role there, and in due course to supplant. And ideally, of course, unlike private law, which is all about correction and going back to the status quo, the whole thinking, once you've got into the technological modality, is about prevention and stopping these things happening in the first place, you know. And if we think private law's got all the answers, why is it that eBay disputes on eBay, millions of them each year, are being settled without any reference, I'd say, to private law or reference to the courts? You know, the technology there is up to that particular job of getting low value, you know, relatively straightforward private disputes settled. Thanks, Chantal.
Thank you so much.
I'll go mute.
for your thoughts on this. Now I can listen to you for hours, but we have more on the program. So I would suggest that we give Christine the floor to briefly react. And Antonio, if you don't mind, maybe you could keep your comments for the conclusion with Talia, and then we can listen to the second session. Thanks so much. Christine, go ahead.
Right, thank you. It would be hard to find a gap in what has not been already said. Thanks for the question. I think I'm going to keep it brief because I understand the time. I really, so Talia, to your question, I think my view is the reason we ended up talking about fairness with my co-author was because we wanted flexibility. We wanted to return to concepts that would be more flexible, malleable, that could change with time, that could evolve with the technology, although the book is not about technology at all, actually. It's more about principle and theories. And for me, a lot of the work that I've done subsequently is to look at how we move consumer law to being this animal and to becoming more of a principle-based type legislative field, especially because a lot of my work is about cross-border e-commerce. So having rules and ticking boxes everywhere is just really not very satisfactory as an approach, but that has dangers. Obviously, if you start having big principles, you also don't know where the judges might go. So it might end up somewhere you didn't quite plan you would end up. And I think you could also, if I look at it from an international perspective, you could end up with an idea of fairness in Europe that would be very different from an idea of fairness in the US, for example. And that also creates its own problems. So I suppose it's finding the balance, but I completely subscribe to this idea of looking at more flexible concepts and how we can utilize them, especially in relation to technology. Marco's question, I completely agree. And actually in the book, we do say the words, we are looking to pursue a standard of substantive fairness. That's where we want to go to. I think the book is candid enough to say we didn't have the answers yet. We kind of worked out all the problems. We looked at what the economics could tell us. And then we decided that, fairness was probably the way. And that was kind of the unifying message. But the last chapter of the book, which I wrote, kind of says, what we want is that, because we can see also in commercial law in the UK in particular, where relationships between two businesses, judges almost have been more creative and have been more trying to find this level playing field. And for consumers, it seems we were like a little bit shortchanged, that there was a little bit of effort to start with unfair terms, for example, but after that, the case law that falls from the UCPD application in the UK is actually really going the European line and doesn't try to be too creative, and we thought that was a huge problem. And Tanya, your question on professional diligence, of course, we do talk about good faith because it is part of the test. It can be added. It's a bit of a flexible element. I'm not opposed to using good faith or any standard that will actually lead to the same result that I want. I'm not someone that think of law as saying my way is the highway, and I really like finding what's my goal, and then we can all get there. I really don't care how we get there, as long as we do get there. So the DSA, for example, with all its failures and its problem, it is one step towards, if you can break big and you can have more liability, then you are acting on that side of the market, which might then ripple through and improve the plight of consumers. It also indicates, for example, that legislators and enforcers will be more emboldened and empowered to try and act against them. I think that in the States, to hear who has been now nominated and confirmed as the head of the FTC is also encouraging. Someone has been fighting against big tech for a long time. So I think all of those are avenues. It's obviously not, I think it kind of rounding up, it's private law has got a role to play, but I find that when it comes to relations with consumers, when you let economic agents to kind of use private law as their main regulatory framework, there will always be abuses. And if we're not careful, then you are destroying, is perhaps not the word, but you are making poorer the side of private law, which can actually be very good. Just to link with eBay is no longer really doing dispute resolution, but they were the catalyst for creating all of those international ADR systems. So I can see how private law does help, and private relationships find a solution, Lex Metoia and all of that stuff. But I do believe that markets, and in particular consumer markets, needs some regulatory oversight, and we need strong enforcement for it to actually happen.
Thanks so much.
And Klaas, I think your question was definitely more for Roger, so I'm not ignoring you, but I think I don't really have much to add to the comments that were made.
Thanks so much, Christine, for this very thoughtful and also positive thoughts of what the role of private law could be in this field. And we're now going to move to the last two presentations. And I already said we have a very international panel today. So we're actually now going to move to France, where Professor Jean-Sébastien Borghetti has joined us today. He's a professor of private law at Paris 2 Assas University and a specialist on liability and new technologies. Professor Borghetti, the floor is yours.
Thank you very much. And thank you very much to all the organizers for kindly inviting me to this very interesting seminar. I have prepared a PowerPoint, so I was wondering if I could share it with the, so I'm going to try that. I'm sorry.
Should be able to share the screen.
Yeah, okay, sorry. So sorry for the little, gosh, excuse me. Sorry for the, let me see. Yes, there we are.
Yes, we can see your PowerPoint.
Right. And so, do you see me? Yeah, do you see? So I'm going to talk about the issue of liability for artificial intelligence related damage and its impact on the balance of powers between entrepreneurs and consumers. So, in case of AI-related damage, you can think of several liability regimes which might apply to provide compensation to victims. I will concentrate here on product liability, which appears as a rather obvious, path to get compensation, even though it's not the only one. And as we all know, product liability is governed in the EU by the Product Liability Directive of 1985, which is actually quite close to, product liability is actually quite close in most countries, even outside the EU, because there's basically worldwide models. So talking about the EU, we are to a certain extent talking about many more countries in the world. And as we know, there are at least two very important features for us in the Product Liability Directive. The first one is that liability is based not on fault, but on defect, more precisely, safety defect, which according to many authors is actually quite close to fault or negligence, but anyway, it's officially defect. And another important feature is that liability rests on the producer or the product's importer into the European Union. While we can say, the application of product liability to AI raises a number of questions or constants which I cannot address all here, which are now quite familiar to people who've looked at the question. The first obvious one is whether a standalone algorithm, which is not embedded in a product, can be considered as a product. That's unclear, that's not decided yet, but there is hardly any doubt that it will, I mean, in the short or you know, one or middle one, it will be considered as a product. It's now official that the product directive will be modified, and there's, I think, hardly any doubt that you know, softwares will be included into the notion of product. So that's not the main issue maybe for us today. Then there's another issue of whether channeling liability on producers is appropriate. And the main issue, which I will concentrate here, is the basis of liabilities, since liabilities is based on defectiveness. What I should say here is that although we've got no precise figures, that's always the problem, but I think that as far as the product liability is concerned, we're clearly faced with a case of under-enforcement. And so it's really topical, I think, to talk about the imbalance between producers and, well, or professionals and consumers as far as product liability is concerned, because, well, if you look at the number of cases which are brought before the courts in Europe, it's awfully small in comparison to the accidents caused by products in Europe. So, of course, I mean, you've got all the cases which are settled out of court, but nevertheless, we don't have figures, but there's a very strong presumption that there is very little liability for accidents caused by products, especially defective products. Actually, if people know some, I'm very interested, but I know of no case, at least in my jurisdiction, but also in foreign jurisdictions, where, for example, where a product manufactured in Asia has been found defective. So in practice, people are not suing. And I think there are many reasons for that. But one of them is probably actually the channeling of liability on producers, because reaching a producer or reaching an importer when a product is being manufactured outside the EU can be fairly difficult. So if you're a producer in Asia and if you're selling defective product in Europe, I think that the probability that you will be found liable for any damage caused by that product is almost nil. Okay? And if you're a product in the EU selling a defective product, the probability that you will be found liable is actually very low, unless you're unlucky enough to become the center of, you know, media attention. I mean, certain products, certain pharmaceuticals become very, I would say, not popular, but everybody focuses on them. But otherwise, I think the enforcement rate is very low. So here we have a great problem. And I think that the problem is even stronger with AI. So, yeah, so here I will focus on defectiveness, and I'll try to show that I think that defectiveness is not a, let's say, an adequate standard for liability for artificial intelligence, which raises the question of how can we have, I would say, efficient or realistic liability for artificial intelligence. I mean, liability which can indeed be implemented by victims. So, first point about effectiveness. So it's obvious that the mere fact that a product causes damage is not proof of defectiveness. Okay, so it's not because the product is dangerous that it's defective. There have been a lot of discussions about the definition of defect in the directive, which basically doesn't say much. But I think there's a quite broad agreement that, in a sense, a product is defective if it is unreasonably or abnormally dangerous. So basically, defectiveness, I think, is unreasonable or abnormal danger. But then how do you prove that? How do you? That's, of course, a complex question. But I think you've got basically 4 ways to prove defect. The first one is proof that the product malfunctioned. If you have a car which, you know, suddenly wheels off the road without any reason and runs into a tree, then it malfunctioned, and there can be a presumption of defect. You could call that res ipsa loquitur. And in such cases, it's actually fairly easy to prove defect. But it doesn't really work for artificial intelligence in most cases, or it wouldn't work. Another possibility is to prove the violation of safety standards. But then you need to have safety standards, and especially in the field of artificial intelligence, where technology is probably running ahead of the regulator, it's unlikely that we're going to have, you know, enough safety standards to prove defectiveness, at least in most cases. So here again, for artificial intelligence, it's not very useful, I think, at least in the short run. Then you can balance the product's risks and benefits, which is for many reasons problematic, and it might not be very easy to use that for products. So the last method, which is actually very often used, is comparison. Actually, more often than not, when you want to assess the effectiveness of a product, what you do explicitly or implicitly is to compare the product with another similar or comparable product. So that's probably what you will need to do with AI. The problem is that it's not the same thing to compare AI, in an artificial intelligence to another artificial intelligence than to compare basically normal product to another product. Because for, so to say, normal products, take a car, for example, you can compare your car to a similar or comparable car. So if your car is abnormally dangerous in case of shock, then you can compare it to another car and you can say, okay, it's abnormally dangerous, so the car is defective. How do you do that for AI? It's not easy. I mean, what should you compare an AI to? First option is to compare it to human behavior. But then it's not, I mean, normally the AI will be better than human intelligence at what it does. That's the whole point about AI, being better than human intelligence. So if you say that AI is not defective because it's better than human intelligence, that it will never be defective normally. So it doesn't really work. Another obvious possibility, of course, would be to look at the outcome of the AI in the case where damage was caused to the outcome of another AI in the same situation. So take, for example, a medical algorithm which makes diagnosis. Okay, so you could say if the medical, well, the algorithm, issues a wrong diagnosis, to know if it's defective, you should look at what another AI, medical AI, would have done in terms of diagnosis in the same case. The problem is, as far as I understand it, I'm not really a technician, of course, but is that, I mean, AIs can work differently. And so, it's not because an algorithm got the wrong result in one case that it's defective, because maybe it got a wrong result in that case where another AI would have got a better result. But it can be that in many other cases, the first AI would give the good result, while the second AI would give bad results. So you should not compare the result in one single case. What you should do is compare the overall results of the AI, okay? And that's been advocated very forcefully by Gerhard Wagner in an article, unfortunately in German. I mean, unfortunately, because not everybody reads German, but which I think is really a very, very good article. And I kind of took over the article, the idea in the article, which I mentioned here, but I think he's totally right when he says that that's the most sensible way to do things. But it raises in turn many questions, because the mere fact that an algorithm doesn't have overall results which are as good as another AI doesn't make it per se defective. Otherwise, you would only have one AI which is not defective, and all the others would be defective. So what can you do? Well, you could say that an algorithm is defective if its overall outcomes are less than X% as good as the reference algorithm. But this, of course, raises many questions. The first one is, well, what is the reference algorithm? Okay, and then what should X be? Well, first of all, how do you get the information about the results? Because it's unlikely that the manufacturers will give you all the reasons, all the results, all the information you want. And then what should be X? Is it 10%, 20% worse as the best AI, etc. So there are even other questions. So when you start thinking about it, it seems to me, so maybe people have better ideas, but at least to me, it seems to be very difficult to demonstrate AI. I think that when the courts will be faced with the issue of demonstrating defectiveness of AI, it will be very, very difficult. I mean, not only will we need experts to do that, but even the standard of defectiveness, how we assess that is going to be terribly difficult. So the path towards, AI liability based on defectiveness, I think, is a very narrow one and a very steep one. So we probably should think about something else if we want to have effective liability for AI. Okay. So what can we do? Well, to be very short, I'm not, well, it's obviously complex issues. I think there's at least two possible paths. The first one, which is actually, which is being discussed already in the perspective of the modification of the directive, is to reverse the burden of proof. So you could say, if damage is caused by AI, then defectiveness will be presumed, and it will be for the producer to prove that there is no defect. So that's actually rather far-reaching, because if you do that, it's probably going to be very difficult for the producer to reverse the burden of, well, to prove that there was no defect for the reasons which have just been said. So if you do that, that's indeed very favorable to consumers potentially, but it's not certain that, I mean, it will happen, if only because it is so radical move. And then if you reverse the burden of proof, why do that only for AI? I mean, why not for other products? So it's an interesting path, I think, but I'm not quite sure it's going to be implemented. So what are the other options? Well, there's at least one, which I think would be to have truly strict liability, i.e. not based on defectiveness, because defectiveness is so difficult to prove. So truly strict liability of the operator of AI, so basically the one who uses AI, which is not as, you know, original or radical as it seems. Why? Because we all, in all countries, I mean, at least in continental Europe, we already have truly strict operator liability in certain cases. And the main, I mean, the first example, of course, and the main example is traffic accidents. In almost all continental Europe countries, you've got strict operator liability for cars. So couldn't we have that for AI? Well, I don't think that a general strict liability regime applying, you know, to all types of AI is, regardless of the dangers, is really makes sense. I mean, you could have, you probably will have AI in almost any products tomorrow. So why should you have, you know, strict operator liability for, I don't know, your watch, for example? It's not obvious. But then it might make sense for, I mean, to have a sector by sector approach and to have certain sectors where you have strict operator liability, basically on the model of traffic accidents liability. That's actually more, I mean, you can find this idea to a certain extent in the recent European Parliament resolution on civil liability regime for artificial intelligence, where Parliament suggests that you could make a distinction between, sorry, suddenly I don't remember the word, but basically dangerous AI and not so dangerous AI. So you could have strict liability for dangerous AI and not strict liability for other AI. But I think the idea makes sense. Of course, you've got to define what exactly dangerous AI is, or what are the fields in which you want to have that. But and of course, it's not so simple as to have across the board, you know, defective products liability or strict liability or whatever. But I think it makes sense. And just to finish, I think the two great advantages of that would be, first of all, that, well, no need to prove defect, because as I said, I think proving defect is going to be horribly difficult. And so if you want to have a good balance between producers and plaintiffs proving defects, it's not reasonable. And then if it's operator liability, I mean, it's normally much easier, I think, for the victim to reach, well, to identify first of all, and then to reach the defendant than if you have producer liability, especially if it's AI, because if your AI producer is in, you know, China or Vietnam or India, just go and fetch him. I mean, it's going to be mighty difficult. Whereas if the operator is the, you know, hospital where you had that medical robot making diagnosis, then it's much easier for you. And then, I mean, the hospital can you know, make a regress claim against the AI designer. So I'm sorry if I was a bit long, but thank you very much. I'm looking forward to your questions.
Thank you so much, Jean-Sébastien. And your presentation was not too long. I think I'm just a terrible chair because, as you can see, we're slightly running out of time. And we have still one more presentation, and I already see some questions. So I would like to ask those of you who are still with us if you wouldn't mind extending till 5:15, so 15 minutes more, so we can really have this nice discussion. I see some people nodding. Thank you so much. And then we're going to listen to Talia, who actually is the one who took the initiative for this wonderful workshop. So Talia, please, as the last speaker, the floor is yours.
Thank you so much, Chantal, and thank you, Professor Borgetti. I also want to share my slides, actually. Yes. Sorry. Yes. I'm assuming most of you know me, but I am Talya Uçarmaz Darbel. I was a postdoctoral researcher, visiting researcher at ACT, but right now, starting from September, I will be an assistant professor in my alma mater. My research consists of the changing nature of postmodern lex mercatoria and the changing, again, nature of contractual relationships, the changing paradigm. And a part of it is on law and technology. Basically, I am interested in the dualism of persona and res coming from Roman law, shaping the current European private law. So my question is, in a future where the market, labor, the household relations are all organized by the artificial intelligence involvement, how should we position private law? And I propose to go back a bit and have a deep historical analysis for having another perspective to demonstrate the central role and the continuum of Roman law as the global DNA of European and global private law. And I want to emphasize that Roman law shows us that law and technology was never isolated from each other. This approach is also adopted by the SPS scholars. So for convenience sakes, I will go with Latour's actor network theory, which emphasizes actually law happens not only before the court, but much before. So right now with the involvement of digital technologies, we are facing new communicative structures like actons, which blurs the lines between humans and things, creates new identities. So ubiquitous technology is changing the nature of what is human or what is res with respect to law. Artificial intelligence can be seen as one of example. I am involved in an interdisciplinary research group called Symbiosis in a Nordic research institute. And basically, symbiosis is a term used to emphasize the togetherness of cybernetics and humans. So it's cybernetic and human symbiosis, which brings also legal issues into spotlight, such as moral and responsible use of technology, corporate surveillance, profiling, manipulation, as Antonio and Kristen emphasized, imbalance in distribution of power, social justice concerns, and responsibility and accountability problems, as Professor Borgetti evaluated. So when we look at this concept, symbiosis, we can also see that this is not new at all. So there was a symbiosis in Rome. Relationship between Roman law and technology was often misunderstood. And when we look retrospectively, we see that Roman praetors, high magistrates, found solutions for the particular problems of freedom and control long before us. And right now, we might be trying to navigate in the same puzzle. So we can, for an example, we can look at the Roman rules on slavery because it has particular characteristics. Slaves lacked rights in Rome, but their legal status was complex. They were seen as hybrids, simultaneously persona and res. They were included in the political and economic ecology of Rome, and actually Orlando Patterson explains this dualism as the practical genius of Roman law because it created no room for ambiguity. So this hybridity owed its existence to a concept of sovereignty, a relationship of sovereignty called Dominica Potestas. Just like many things, it also derives from the Aristotelian philosophy. For example, in Politica, Aristotle uses the word oreganon to refer to slaves, basically meaning the prosthetic extensions of the master, the instruments. From that particular view, Roman law or European legal history accepted the derivative legal capacity of the owner and of derivative legal capacity of the slave as an extension and for the interest of the owner in the everyday business life. We see this continuum today. For example, US Supreme Court describes this involvement of cell phones as anatomic features of human beings, or European parliamentary resolution emphasizes that the more autonomous the artificial intelligence is, the less they can be considered as pure instruments. This also reminds us this Hegelian approach of the lordship and bondage dialectic, in which the status are changing places, changing positions. So as an example, or as a practical legal example of this philosophy, we see this understanding of vicarious liability, which is the liability irrespective of fault. Basically, Roman law shows us that the idea of strict liability was a matter of personhood, because in Rome, special legal instruments to hold the owner liable from the slave's acts or actions were developed. And they were developed only for one reason: equity and fairness, because they were not developed within the sphere of jus civile, civil law. It was through the involvement of praetorian law, which showed us the mutable characteristic of law in response to changing power imbalances. Basically, through this continuum, we are facing this legal construction in which the principle is liable for the actions of intelligent actors, intelligent beings. In Rome, for the responsibility attracting conduct, for example, there were two concepts: peculium for contractual liability and noxal liability for extra contractual matters. Peculium basically referred to a special fund. The slave was entrusted with that special particular fund, and the owner was found liable up to the extent of that particular fund. And noxal liability can be understood as an initial type of compensation cap, and the owner of the slave was held responsible up to the extent of that current market value of the slave. This continuum can be seen in today's doctrinal discussions of the liability of, from artificial intelligence, such as the views of benefits from artificial intelligence should be taxed based on the revenue generated, the views of limited liability or mandatory insurance funds. We can see all sorts of reflections of that particular view. However, when we also consider the relationship between private law and policy, Hugo Grotius was also important in that regard, because he saw liability for others in the absence of fault wasn't a rule of jus gentium, and it was also not a rule of jus civile. Basically, it wasn't a rule of natural law, and it also wasn't about civil law either. It was introduced for ex rationibus peculiaribus, simply policies. Today, we can interpret this by developing our theories about the liability of artificial intelligence, whereby we think of certain parameters such as the level of the risk, area of usage, degree of control over the artificial intelligence, access to information, or questions about whose behavior caused the damage or who benefited from the high risk activity, who can easily take ex-ante measures, and so on. Yet, maybe we can also remember that today, with the changing paradigm, we are in this atmosphere of entropy, and the penetration of AI into our daily life might require us to re-evaluate the logic behind this legal architecture. So what we face today maybe is a new legal ecosystem which creates fairness concerns and also unfairness concerns concentrated in the societal exposure to artificial intelligence. So artificial intelligence, in one way, yes, it's blurring the line between persona and res, but it's also blurring the line between private home and the public exterior. So maybe it might be best addressed holistically as a combination of compensation and anticipatory regulatory initiatives together. So from the words of Günther Teubner, he says, he uses this term breaking the frames for globalization, and I adopted it for Roman law. Roman law actually broke the frames because it broke the frame between what is human and what is a thing. And it actually shows us, history shows us, that human essentialism cannot be found in law. So as lawyers, we should teach others about this idea of distributed sovereignty and subjectivity not being singular. And historically, we see that private law had a leading and transformative role. Yet today, we again, with this change of paradigm, we see that we might need a new understanding of fairness. So we might need an apparatus that will show this plasticity of private law, which emphasizes again the importance of regulation and liberal application of freedom. Yet, my research is basically revolves around this raising the question to what extent we want artificial intelligence to take this dual position as persona and res should be an essential part of how we regulate the artificial intelligence. Thank you so much. I try to be within the time limit. I hope I managed.
It was perfect, Dalia. Thanks so much for this innovative perspective on the issue, going back to Roman law and then looking at what it can teach us for today. And I liked very much that at the end of your presentation, you actually went back to the beginning of our discussion relating to the concept of fairness. So I'm sure we can have a nice final round of questions on this. Thank you so much for everyone who is still here and for the lively discussions. I have on my list Christine, Marco, Antonio. Yeah, I think that's it. So Christine, please go ahead.
A very brief question, which actually has been partly answered by the speaker that followed, Talia. So, yeah, because when I was listening to the first talk, I was actually wondering how much of the solution could reside in vicarious liability or in liability also that we may have for employees when we are an employer, or what liability could also go for something completely different, so not liability for humans effectively, but for things. So I know that in England, I think it's not a legend, but apparently there's a rule that if your dog causes any damage, you're liable for it, but if it's your cat, you're not. Whether that's true or not is kind of irrelevant. So I wondered whether we could also, or if you had explored things like this, so could we actually map out some liability regimes on things that are already there, but perhaps not for humans, but for things or for animals, or so that was my question.
Thank you so much. Yeah, and I think this topic inspires us to think of how we can apply already existing mechanisms to these new questions and to what extent they can really fit. Marco, please go ahead.
Thank you. I have a short question for Jean-Sébastien. That is, if you are proposing to go for strict liability without any possibility for to escape liability because you argue that the AI was not defective, then the question is whether there should not also be something like compulsory insurance in that case. So that is of course what is happening with traffic liability. Is that what you advocate as well? And aren't we making insurance companies very rich in that case?
Thank you, Marco. Antonio, you also had a question.
Sure, I try to be as fast as possible. Actually, my question is about strict liability as well for Professor Boghetti. Now, it actually goes to the aspect that he was mentioning of going per sector and distinguishing between low-level risk and high-level risk and having strict liability for high-level risk. So why I see the conceptual idea behind that, I also see a potential risk, which is the fact that the so-called high-level risk artificial intelligence are actually the one that we want to be implemented faster. And I'm thinking, for example, autonomous vehicles, which definitely will be into the high-level risk, but those are often, or I don't know, surgery, artificial intelligence, which are actually the one that brings more benefit in the immediate application, as long as they are marginally more efficient than the human, which is, as you correctly said, a requirement for the AI to be employed in the first place. So I was wondering whether actually this solution might be counterproductive in terms of jeopardize the usage, actually the commercial widespread of these technologies, because I see that being a major problem with this approach.
Thank you, Antonio. Dalia, you also had a question.
Yes, thank you. I have a very short question for Jean-Sébastien, if I may. The idea of tracing down the producers is really crucial in this topic. And I noticed that some researchers propose the term production liability instead of producer's liability to emphasize the untraceability of one singular producer in this today's complex economy. I was wondering what are your opinions on that matter, because it's also not a very established concept. Of course, if we take this product liability solution instead of the operator's strict liability. So I was thinking about that. Thank you.
Thank you so much, Dalia. Dalia, I see in the chat also some enthusiasm for more of your work, so you can maybe email the other speakers one of your papers later on. I'm going to add one more question to this round myself, and that is about the concept of autonomy that you spoke about, Dalia, because I was wondering, some artificial intelligence is so intelligent that it's learning itself. And then my question is, what does this mean for the autonomy of AI, and when does it become like so far removed from the original programmer that we cannot establish liability anymore? And so when does it become so autonomous that it might be difficult in the law to find a basis for liability of the human being who actually developed it? I'm going now to give the panelists the floor in order. So Jean-Sébastien, please go ahead.
Well, thank you very much for all these very interesting questions. So, of course, vicarious liability. Here I can only repeat what has already been said. That is, I mean, to a certain extent, there's nothing new, or at least there's nothing new about being faced with new technological challenges. And it's, I mean, that's what Brownsworth has said, and that's what Talia has said. And so, I mean, it's for a very long time, we've had people being liable for damage which they have not personally caused, but which they have caused, which either other people have caused, so vicarious liability, or which have been caused through animals or things they use. So there's really nothing new about that. So, of course, we could think about vicarious liability, but I don't think that it's per se an answer, because the problem with, I mean, generally speaking, well, usually vicarious liability is liability of someone for damage caused by somebody else's negligence or fault. So you can use vicarious liability if you want, but then you'll have to define what the fault of artificial intelligence is. So, and basically, I think it boils down to the question of defect. So it really does make sense to speak about vicarious liability, especially if we consider that artificial intelligence will have some kind of autonomy. But I don't think it changes the basic issues which I have addressed in my short presentation. So that's the first point. The second point about insurance, well, I think that there's a, generally speaking, about liability, there's a, psychosociological dimension. How do we, as a community, how do we assess risk, and what do we believe about the way in which risk should be allocated, basically? And there are some fields in which we say, well, that's a serious social risk, and it can be that the risk will materialize because someone was at fault or there was something which was really wrong, but that's not for us the main issue. Well, basically, we consider that the risk is one that collectively we want to take, but if the risk materializes, then basically it's bad luck for the one who is the victim of that risk. So we choose to basically to collectivize, well, to share the risk. That's typically what we do with traffic accidents. So it might be that your traffic accident was caused by a defective car or by someone driving negligently, but it might also not be the case. But we don't want to go into that inquiry too much, because anyway, it's complicated. And basically, we know that we want cars, they're useful, but accidents happen. So basically, if you're a victim of a traffic accident, it's kind of bad luck, but you're paying the price for a collective choice we're making. And so we decided to share the cost of that among the community, or the community of all those who are insured. And I think we might want to do that with artificial intelligence in certain fields. For example, we could say that, well, for medical diagnosis, well, medical robots will probably be better than human doctors, but then you might be the victim of a wrong diagnosis. So basically, it's bad luck, and we want to share that risk among many users, all that. So of course, an obvious way to do that is to have insurance. But I think in some cases it might be necessary, but you don't absolutely need insurance to share the cost, because I mean, if someone is made liable, then he will share, he will or she will share the costs among all the users of the service. So he might want to take insurance behind to cover himself, but he might also, you know, auto-insure. So I think it depends on the size of the risk. There are some cases when you need insurance because if you take, for example, I mean, if you take traffic accidents, the persons liable are individuals, and you cannot expect an individual to pay out of his pocket the cost of someone being severely injured by a car accident. So you need insurance. In other sectors, insurance might be very useful. I mean, it will certainly be offered by the market. Do we need to make it compulsory insurance? I'm not sure. I know that insurers are not always very much in favor of that, but I couldn't tell. But I think we can do, at least we can share the cost without insurance, although it's of course very useful. Then the question about liability jeopardizing, you know, innovation. That's of course an issue. It's something which is very much brought forward. I must say, but it's maybe very personal, I'm quite skeptical about that, because I mean, we've heard that about product liability. You know, product liability will stifle innovation. I don't think we are lacking we have been lacking innovation over the last 40 years, and I don't think we've had that much liability. Actually, I don't know many sectors where there is so much liability that it obviously, you know, stifles innovation of economic activity, at least in Europe. Maybe it could be that in the 1980s in the United States, in certain sectors, maybe medical liability, then maybe liability really had a stifling effect. It could be the case, but in Europe, and certainly in the field of product liability, I don't think it ever was the case. So I would say we can take the risk. I don't think it will stifle innovation, and if really it does, then, you know, let's just change the rule. But I don't think that it should prevent us from going ahead on that. And then on the last question, I'm sorry if I'm a bit long. I'm sorry, Talia, because I'm not sure I heard correctly the concept you used, which was not producer, but
production liability, I think, to
yeah,
a more holistic focus, not to a singular producer, because it's at least they are predicting with the change of technology, it will also decrease our ability to trace down what is exactly produced by whom, and since everything is super intertwined, they came up with such a concept, certain researchers. So that was actually what I was thinking. Yeah,
well, I do agree. I think producer liability is too strict in the sense that it's difficult very often to identify or to catch the producer, and the little number of cases illustrates that. I mean, a simple way to do things would actually to switch back to what existed before the Product Liability Directive in several countries, which was basically professional sellers' liability, which was refused. I know it was it was the subject of much debate when the PLD was discussed more than 40 years ago. Well, 40 years ago, some countries were very much against it. Here again, I think the risk for retailers was grossly overstated. I mean, well, I'm not an economist, but in France we had retailer liability, and we had a very strong, you know, retail industry. I don't think that the retail industry will really become, you know, stifled if there's retailer liability. But sticking to producer liability, I think, is the best way to have well, to have no liability in practice. Actually, it's interesting because you're starting to have a few cases. There are a few, I haven't studied that in detail, to be honest, but there's at least a couple of cases in the United States and California which are interesting, which have found, there's at least one case which found that Amazon was liable for a defective product. So actually, Amazon might not even be the seller. So it's basically platform liability, but you can see that as I mean, it's always the same idea, just not channel liability only on the producer. And I think if we want to strike a good balance between the interests of basically consumers or victims and professionals, then we must, I mean, liability must lie on someone whom the consumer must be able to reach. And the person who is most easy to reach normally is the person you bought the product from, or on whose platform you bought the product. So from that perspective, I think platform liability is, of course, a very good idea. It's much more, I mean, if you buy a Chinese product on Amazon, you're never going to go to China to get redress. But if you can go to Amazon, that's good news, or that would be good news.
Thank you so much, Jean-Sébastien, also for this positive note. We're really running out of time, so I would now like to give the floor to Talia, the last word, to answer the questions and then also go towards the conclusion of the workshop. Talia.
Thank you so much, Chantal. I first of all, again, would like to thank all the wonderful speakers, to Roger, Jean-Sébastien, Christine, Antonio, and you, Chantal, for being our moderator. I think it was a great discussion because I really liked how we approached very critically towards private law. All the speakers had this critical perspective, which is maybe the first step to develop a better theory or a better focus for this result we aim for. So therefore, I would like to thank once again to everyone.
Thank you so much, Talia. I think you summarized it perfectly. And I would like to extend my thanks to both you, Talia, and to Antonio for making this possible, for organizing this even at a distance, but still making it feel like we were in the same room, having this very important and lively discussion. I thank the speakers, Roger, Christina, Jean-Sébastien. Thank you so much for joining us this afternoon. And thank you to Marco for his interventions and also to all the other participants. It was really a wonderful, lively discussion. I wish you a lovely afternoon and hope to see you soon somewhere offline once that becomes possible. Thank you so much.